And we're back with Despina Priala from Priala Legal. And for this segment, we'll be discussing buying property with someone else. Whether it's your spouse or business partner, what does it really mean if you choose to sign as a joint tenant or tenants in common? So these two terms might not be common knowledge, obviously, for everyone, Despina. So can you tell us exactly what they both mean?
Yeah, absolutely. And it's a really important distinction to note and to understand. And sometimes people buy property without even knowing what they've put on the title, because there are default positions as well at law if you don't make a decision. So we'll get to that. But joint tenants versus tenants in common. Okay, so when you own property with more than one person, you can own it in either capacity, joint tenants or tenants in common. If you own it as joint tenants, it means that you and the other person or persons, you each own basically 100% interest in the property together, collectively. And the big distinguishing factor between joint tenants and tenants in common is this: it's the law of survivorship. So say if you and I, Brooke, own a property together, and if I die first, the law of survivorship, if we own it as joint tenants, means that you actually receive the property automatically upon my death. So it's the law of survivorship. Makes sense? The survivors, the surviving owners, receive the property automatically. Now that cannot be changed by will. So if I made a will and said, you know, my house that we own as joint tenants, I'm going to give it to someone else, well, that'll be void and invalid. So it's the law of survivorship. You can't change that by will or by deed. So versus tenants in common. So if you and I then own the same property and we decide it's going to be tenants in common, so there, the first thing is we decide, well, what are our interests in that property? So do we have 50-50? Do we have 60-40? Do we have 70-30? Or whatever the percentage of shares is? Maybe I'm contributing more funds than you are, or maybe vice versa, or for some other reason, we don't have equal shareholding. So that's the first distinguishing factor. But the second distinguishing factor is that each person can decide what happens to their interest in their will. So you can actually deal with it in your will and give it away, or dispose, I could call it, in your will to someone else, to say my interest in this property is going to person X in my will. Okay, so those are the big difference you can see between owning a property, and it has obviously consequences from an estate planning point of view. And I can give a very, very good example, and it's seen more, I suppose, not more relevant, but more of an issue with blended families and second and third marriages, where you might have children from different relationships. So we had a client recently who bought a very valuable property with his second wife, and the husband was contributing all of the funds to the purchase of this property. Now, this person had a previous marriage many years ago, and has 4 children with that ex-spouse. So he's got 4 children on the one hand over here with a different partner that he wants to look after down the track when he passes away. And in the new relationship, the new marriage, he's got another child. So he's got 4 on this side with this person, and he's got 1 child with his new partner. And he's just bought a property with this new partner, with his new wife, and has this wife and this son to look after, as well as the 4 children from the other marriage. So how does he do that when this particular property was very high worth property, and he wants to make sure that everybody is looked after? So if we run through the scenario, if they owned it as joint tenants, then if he died first, you can see what happens. Messy. The house automatically goes to his second wife, who would undoubtedly, in her will, give it to their son, right? Because she doesn't owe anything to his other 4 children on the other side here with his previous wife. And is that really what he wanted? If the property goes to the second wife and that child, then his 4 children on this side miss out, don't they? Right? So really, really messy, and not what he wanted or intended at all. So what we did there is that we actually set it up so they own it as tenants in common. And then it got a little bit trickier because we had to decide the percentage of shares. Because you've got 4 over here on this side and you've got 1 over here on this side that both have to be taken care of. And he said to me, well, my goal is that everybody gets an equal share.
Equal. Yeah.
So how do we work that one out? So we then had to split the shares between himself and his new wife. So he had 3/4 interest in the property. She had 1/4 interest in the property. So when she passed away, her quarter would go to the one son, and then the 3/4 would then be split over to the other children from his first marriage. And that worked out really well, of course, down the track, if or when he passes away. So that's the idea of, thinking about the ownership of property, the different consequences, what it means for you. And there's no right or wrong answer, right? So people ask me, well, what's right? What's best? What do people normally do? That's a common question. What do people normally do? How do they normally own property? So I don't know if there's any normal, because everyone is in a different relationship, and everyone has baggage and history, and not everyone is lived or been married to the one person for 40 years.
Yeah.
Right? And a lot of people wouldn't have an idea unless they consult you.
Exactly. No, they wouldn't. They wouldn't know at all.
And then they're probably shocked.
Yes.
In some cases.
And especially for young couples as well going into it. Naturally, do you find that they do go into the first joint tenant agreement? Because things are lovely and they do expect to just give everything to their partner. They're not really thinking far down the track. Do you think it's almost safer to go with a common tenancy agreement?
Well, sometimes it is, sometimes it isn't. We always ask the question. We never ever allow someone to buy a property without asking that question. Are you going to own it as joint tenants or tenants in common? It's the very first question that we ask them, and we ask them to put it in writing. We have a discussion. What does it mean for them? Because when you act for someone when they're buying property, you don't necessarily know what's happened in their past, about how many relationships, and do they have children from a previous relationships, and those are the questions we ask from an estate planning point of view. So we always have that discussion, and then a lot of interesting things come out. But I suppose you could say it's more common than not with married couples that it is joint tenants. But as I said, with second and third relationships, second and third marriages, it's not necessarily the right thing to do from an estate planning point of view.
Yes, yeah. And if you do have, say, a tenants in common, what happens if you do... Sorry, let me restart that. If you have a joint tenancy, if you split completely and you... Hang on, let me get my words right. Am I talking about joint or joints in common? Go to your nominated person in your will.
So we'll be editing this.
Yes, edit it. It's called... severing. I just wanted to.
Oh, yeah. Yes. So I was going to mention that right at the end.
Oh, sorry.
That's
okay. So joint tenancy, it can be agreed upon all parties, or just one.
It can be. So what you probably want to introduce it by saying, but can it change? Can the parties change that themselves at any?
Yes. Okay. Cool. Yeah. So if you do have a joint tenancy, can the parties change that at all themselves?
Yeah, good question, and that's something I was going to mention as well, that when you do decide to own property as joint tenants, there is a rule at law that one of the parties can actually sever the joint tenancy, and you can do that unilaterally. So that means that if we own a property as joint tenants, I might decide, you know what, I don't want to own it like this anymore. I just want to sever it. And you can make lodge certain paperwork with land titles, and you can sever it, which means it then becomes tenants in common, and the other party may not necessarily know about it.
Oh, and then with tenants in common, you can't actually step away from that without the other party agreeing. Does all parties have to agree?
Well, it's just a different concept.
Yeah.
So what you're doing is you're changing the structure of the ownership from joint tenants to tenants in common, and you can do that unilaterally, and you can sever it, and the other party won't know, and then come the time when the person passes away, they may not know that, we actually own it as tenants in common, not joint tenants. So
have you ever experienced that? Someone springing that on someone else and being like, surprise?
I have seen it happen. So there's a procedure to follow, though, and you are supposed to notify the other party of that, but sometimes it doesn't happen. So just be aware of that. It can happen.
Thank you to Despina for being with us again every Thursday. From Priala Legal in Runaway Bay. If you are seeking legal advice or you have a question for Despina, please call her at the office 075529 1294. You're listening to Radio 97 and email us, of course. You're listening to Radio 97. Email us at breakfast@radio97.com.au. On the Gold Coast, FM 104.1 and FM 103.5 Northern Rivers.